Thank you very much, and welcome to this small workshop. We have 45 minutes. It's intensive topic because we've been working on, for me, since already 10 years. And basically the topic of the small workshop is about the right to digital integrity of the human person as a new framework for data protection. So on the panel, we're four. We were supposed to have some other people, but I thought there was like a remote conference didn't work, so there was a bit of a change. But we have a lot of people still present and key people in this process. So Lusine Vardanyan next to me, she's a lawyer, researcher, and PhD in law. From the Czech University of Barclay. Alexander Barclay, he's a delegate for digital policies of the Geneva state, so he's a government official. And Harry Halpin here, he's CEO of Nym Technologies, former W3C member, a lot of activities. So, and myself, Alexis Roussel, I also work at Nym, but I'm a lawyer, activist, former president of the Swiss Pirate Party. So I was also doing some politics in Switzerland. So why we're here? Lusine here wrote a research paper about the right to digital integrity that I suggest you should read. It's an excellent paper. It's called Digital Integrity, a Foundation for Digital Rights and a New Manifestation of Human Dignity. And so she will actually explain a part of this. And also how her paper is a critic about GDPR, and it's really interesting. Alexander is leading the constitutional change process within Switzerland. So this right to digital integrity actually went very far to the point that it's going to be voted in June 2018. June this year, sorry.
On the 18th of June.
On the 18th of June, it's going to be voted by the Geneva people, and it will be added into the constitution. So it's a very lively topic right now, and we'll go through this. And Harry is leading Nym, which is a privacy company, building a privacy infrastructure, and we also co-wrote a paper about how preserving privacy with technology is, and we saw how MixNet, which is a specific kind of technology, is actually helping data protection. So, and it has a link to it. So myself, I'm Alexis Roussel, I'm the CEO of Nym, and I wrote a book called Our Precious Digital Integrity. So that's a few years ago. I organized the doctrine work in Switzerland with a university conference that was organized a couple of years ago in Neuchâtel, where all the scholars of the Neuchâtel and a bit around went and make analysis of what the right of digital integrity is and how it could be applied. So before I give people the floor, so we'll start with Harry, who's going to give this approach where actually this is a kind of tech that is led by technology, goes together, right? If we didn't have the technology element, we wouldn't be that far in this perspective. Then we will go to Alexander, who will show us how the process happened in Switzerland, how the government or the political parties and the governments took this subject and how now they are using it in their policies, or at least in their mental model. And Lusine will deep dive into the structure, the legal structure, how this right, the right to digital integrity, is fitting in the human rights in general, and how it can give a new framework for GDPR. So what is the right to digital integrity? That's maybe the first question. And there's two main elements of it. There's the basic definition of it is that in a normal construction of law, you have a right to physical and mental integrity, which is existing in most of the Constitution or most human rights charter. And so the idea is to add digital integrity to that list. What does happen when you add this digital integrity? Then you start to think about the person as a whole and not just data. Data becomes an element of the person, and that has been also the first proposal done by CNIL, the French CNIL, and all the association, all the data protection agencies. The French-speaking one, they made a declaration that data is an element of yourself with unalienable rights attached to it, rather than a commodity or a public good. And so basically it kind of answers the question of what is data. The American system is pushing for data as a commodity. The Chinese system, as a very big group, is pushing for data as public good. And both systems are based on collecting data. And here the proposal is that data is part of yourself and is treated legally the same way as the body is, actually. Which will push the governments or the institutions to have a system where there's no data collected rather than collecting by default. So I wrote a book about it. There was this process, and at the same time technology was picking up. So maybe Harry, maybe you want to explain a bit.
I can also give a little bit of a what's called a thought experiment, and then I'll talk about the technology. So I actually did my PhD under a philosopher called Andy Clark at Edinburgh. And Andy formulated this hypothesis called the extended mind hypothesis. And Andy said, imagine there's a person, and there are people like this who have neurological issues, that has a very short-term memory loss. And they need to navigate, let's say, from one part of the CPD conference, let's say Area 42, back to the main hall. And in order to do so, because they have short-term memory loss, and many of us suffer from various forms of lack of memory, they have to write it down on a map. And then they follow that external map to get back from Area 42 here to the main CPDP venue. And Andy said, in terms of accomplishing that cognitive task, the holding of the map and the reading the map and the using the map forms an essential part of an extended cognitive process, and therefore deserves some kind of credit, cognitive credit for accomplishing that task. And that seems kind of obvious, and you can debate kind of various gray zones in this thought experiment, but it's a kind of Dan Dennett style intuition pump. And the intuition is trying to deliver is that humanity naturally, and has done so through the creation of, symbolic culture and architecture and many other things, naturally outsources a lot of our cognitive capacities, intelligence, to the extended environment around us, to our milieu. And if that is indeed the case, then the question is, if that map was replaced by a smartphone, you need that smartphone to get from place to place, as most of us do, then that smartphone feels very personal to us. It almost feels like it's part of our extended cognitive sphere, and thus has maybe some right to privacy. Because, what is disturbing for many people is the thought that, what if your thoughts could be used against you? What if there was a open AI-based mind reading machine, ChatGPT 666 or whatever, that could read your mind and then display it, on the screen behind you? That would be a violation somehow of your fundamental privacy rights, or your fundamental rights, your mental integrity as a human being. And if you say, well, my mental integrity is not necessarily arbitrarily blocked by the boundaries of my skull or my skin, then this integrity requirement would then naturally pass into the digital sphere, into digital technology at least. And that there's an intuition that digital technology should then have if something is kind of functionally equivalent in terms of accomplishing cognitive task, then there is some natural, correspondence between digital equipment that kind of slots into the same functional space. And that means that technology, is not just something which is outside of us, but is somehow also inside of us, but there are certain uses of technology that have reasonable requirements for privacy, among other rights, and that the human itself is kind of extended organism, and therefore human rights should extend outside of that organism. And this should require us to build technical infrastructure, in the case of my company, Nym Technologies, digital technical privacy infrastructure, that maps to the intuitions that you have when you are when you're without this technology. So for example, if I'm talking to you in a room, I naturally do not assume, unless I'm perhaps being filmed, that there are an unknown number of people in a different geographical location listening to me. I assume that our conversation is private. If it's not, I'm being spied on by my smartphone, wiretapped, or so forth, and that's illegal without certain legal requirements. And so what Nym is trying to do is Nym is trying to take this kind of natural intuition of privacy, that when I'm sending someone an email, I don't expect everyone in the world to be able to read that email. I don't even expect that people should know that I have emailed you. But the fact of the matter is, the way that technical infrastructure has been built today, when I send someone an email, not only can anyone read that, the content of the email, but even if you encrypt it, the metadata in that email, the fact that I have emailed, for example, Andreas over there, that is valuable information. And there's been work by scientists like Pentland and MIT, which shows that actually this metadata, this who communicates to who and when, is often very good at predicting future behavior. That it's actually better than the content. You don't have to watch. You almost don't need to know what someone's saying. You just have to know who's talking to who, and you can predict, 70-some% of human behavior. That's a reference to Pentland's work in a journal called Adaptive Behavior. So if this is indeed the case, this is very dangerous that this data is not protected, and we should protect that data so that the use of our communications in the digital world maps to our intuitions about our communication in the non-digital world. And that's exactly what our company tries to work on. We have a product called Nym, which is a mixed net, like a super VPN. But when I use a VPN, the VPN provider knows who I'm talking to. And anyone that's watching the VPN provider knows who I'm talking to. And the VPN provider can also, decrypt my messages, so forth and so on, unless you're very careful. And even with Tor is very powerful, but it's not a magical box of anonymity that if I'm using Tor, I'm sending some signals, some communication over a few different hops. But if I'm watching the entry nodes, the people at the first computer into Tor and the last computer outside of Tor, and I see the same pattern of messages coming in and the same pattern of messages coming out, then I can link those two patterns because the patterns will be statistically very similar, if not very close to the same. And a mixed net defeats that because a mixed net, when you send a message into a mixed net, it gets held for a period of time. Another message goes into the mixed net by maybe another user, another one, and they're kind of mixed up like a deck of cards. You just shuffled, let's say, and they come out in a different order that they came in. And this sort of mixing process preserves the privacy of metadata in communication. So just to summarize really quickly, I do think as humans, a lot of our intelligence, our mind, so to speak, our mental space is crucially dependent on digital infrastructure. That digital infrastructure should preserve the same rights that we expect in our mental space into the digital sphere. And Nym basically preserves the right to privacy in the digital sphere, more so than any other kind of generic communication pipeline or VPN. That's it.
Thank you. And I think that's a very good switch transition with Alexander, because actually one of the political discussion that was happening in not only in Geneva, in the whole Swiss Romand, is when we were saying that when the federal government made a very traditional proposal for cloud infrastructure, and basically they made an offer for a public tender, and all the Swiss companies were refused. and all the companies that were accepted were 4 Americans and 1 Chinese. And so all the local governments were who had this like intuition that data should be kind of managed locally for the data of their own citizens, they were pushed to use foreign systems, which was just selected based on very cold criterias, right? And now the topic of like what kind of the data is, what is the data, and that we should also start to think about the individuals in their perception on how their data is going to be processed, is now being used in the process. So maybe you want to take it from there and explain a bit how it happens in Switzerland, in Geneva first. Yeah.
Absolutely. Thank you very much, Alexis. Can you hear me all right? I think we're a small room, so it's microphone maybe on top. So first of all, thank you very much for the invitation. Thank you as well for putting this important topic of digital integrity on the agenda of this very relevant conference. I think a lot of what we are saying here are things that sound very familiar to you. I think we also need to remember that when we're working with policymakers in general, not everyone has the same sensitivity and awareness of the impact that data can have on future developments, on freedom and on democracy in our societies nowadays. So that's an important point. Geneva is one of the 26 cantons of Switzerland. So it is sovereign, it has its own constitution, and the national government does all that is listed in the national constitution. It is in the French-speaking part of Switzerland, and we observe in terms of digital policy in general that French-speaking Switzerland or Latin language-speaking Switzerland, to give a nod to our friends in the Italian-speaking part of Switzerland, have a way more political approach to digital policy. So broadly speaking, take the example of cloud policy, which you just mentioned, the choice that all public administrations have to make in regard to cloud. You can either consider it from a very technological or technocratic approach. Do we have a contract that allows us to benefit from all these services? Or you can tackle it from a more fundamentally, originally political point of view. What do we want from a grand political standpoint, our cloud policy to be? What do we want to reach through that? And how do we defend our digital sovereignty in that context? And so that's what the French-speaking cantons did, and we'll get back to that. First, on digital integrity. So I think you'll have understood that Alexis Roussel here has been instrumental in pushing this topic in French-speaking Switzerland, in bringing it forth in a very constructed. I think there'd be a whole for those of you looking for a policy-making research paper, there'd be a whole paper to write on how you went about bringing this topic and having it discussed in local governments, eventually also on the federal level, by astutely, and I was going to mention it, setting up a conference, an academic conference with researchers at the University of Neuchâtel. I think it was 2019 or 2020, presenting it in a book, the general argument, to address, say, a broader non-scholarly public, and then convincing eventually, because that's how it works, convincing members of parliament in different cantons to actually bring the topic on the floor of the parliament. In Geneva, it was a right-wing MP. I think it's worth noting that in some other cantons where it's being discussed in parliament right now, it was put forth by left-wing politicians on the national level. That was the case as well with the socialists. And I think that's really interesting in and of itself, to observe that it's a topic, including a new fundamental right to digital integrity, that can be carried by either side of the political spectrum. So the government in Geneva decided to work with Parliament on this new fundamental right, to elaborate it a little bit, because this notion of a fundamental right to digital integrity is something that does not exist in Swiss law, in Swiss jurisprudence. So if you just include, as was the original proposal, an additional dimension to the right to privacy, saying that every person has a right to digital integrity without adding anything else, well, that's something that was discussed yesterday in the opening conference. You run a risk. How will the judge rule when a case is brought? What does it mean in Swiss law and in Swiss law practice later on this notion for digital integrity. And so the government worked with the parliament to specify, to add illustrative dimensions, which I might get back to later in the conversation. I wanted to mention that there was no fundamental opposition in Parliament to this new fundamental right. It is a new article in and of itself, so a new Article 21A in the Catalogue of Fundamental Rights, and some of the dimensions of digital integrity are covered by existing fundamental rights, like the right to personal freedom, the right to privacy. A fundamental right has two dimensions. One is the effective right, so what you can use in a court to oppose something the state wants to do to you, limit one of your rights. And the other one is the symbolic, the political dimension of a fundamental right. And in that, the state can also influence certain practices, hopefully, also in the public, in the private economy. The proposal is not focused on a technology. You don't modify your constitution that often, really. So the idea is to have here a description of a digital integrity that is sufficiently robust on the principles, that it is not related to, say, AI, which was discussed in a session just before, organized by Microsoft, on how generative AI is challenging our fundamental rights. What I do want to stress as well is here in Geneva, what was done was to broaden the scope of the individual right to digital integrity and relating it to the digital sovereignty of the country. So sort of the individual's right is fundamental right, is anchored in a free and democratic society that is able to make its own choices. So sort of relating these two, I wanted to mention as well. The vote will take place on June 18th, 2023, and we'll know then if the Geneva Constitution is modified.
All right. Thank you. So that brings me to the also like the current situation that we talked about already, like the right to privacy, which is usually the entry point of data protection, right? And one of the reasons why I started working on this is I always felt that the right to privacy was actually too limitative in terms of addressing these data protection in general. And one example is the following: take a government or a state which is keeping knowledge of zero-day attacks in his database, in case of using it sometime against someone. What it creates holes in the network, potential holes. I mean, they keep intentionally holes in the network, and it puts people at risk because they can be attacked by any criminal who has knowledge of these 0 days. And there's a market of 0 days, so it's an actual threat. And when we say that this is threatening individuals, the answer is, well, but it doesn't threaten your privacy, because we don't attack anything of your privacy, so it's okay, we can do whatever we want. So I wanted to find that gap. So in the German courts and it was taken also by the Swiss court, has designed this this concept of informational autonomy. But again, which is trying to say, well, if you are touching the data, if you are in charge of data, it needs to respect this informational autonomy of the individual. But again, this term is put within the context of the right to privacy, Article 8 of CDH, which if I remember right. And then comes that to you. So exactly, that's the point of the research, because actually this limitation was, I think, one of the first part of your work. Maybe you can explain how you connected this right to digital integrity to something larger, right? So Lusine is not very. It's her first conference in English, so we'll support her, and so we'll be very forgiving on her conference. But please.
Thank you very much for your invitation. It's a very interesting topic, and I represent it now. Imagine you were spied on. What feeling will you have? Psychologically similar to the feeling of unwanted touch, maybe the violation of sense of dignity or sense of integrity, right? And are we safe from such kind of technologies by means of personal data protection regime? Unfortunately, the answer is negative. Until 2016, the European Court of Human Rights, in its case law, developed strict criteria for surveillance, which made it difficult to conduct. But now, in the case of Big Brothers versus UK, the court conducted that mass surveillance per se does not violate of Convention on Human Rights. As for GDPR, it doesn't contain a legal mechanism to protect personal data from hacker attack, political targeting, or data collection for reason of national security. Despite it is considered as a legal instrument for implementation of right to personal data protection. It is possible to talk about the imperfection of law in this area for quite a lot of time, but what is the solution? The solution should be a comprehensive, value-oriented mechanism for protect of the whole person in the digital world, which can prevent the further deepening the attitude toward the personal data as economic assets, manipulation of person through his data, cyberbullying, and other malpractice. And here we come to the main point. What do we offer? We propose the introduction of the right to digital integrity as a fundamental right similar to the right to personal integrity, which has long been a mechanism for protection against the risk of biotechnology and which is the cornerstone of human rights. Having the genetic connection with the concept of personal integrity, the digital integrity can bring this strong potential of protection against these technological threats to the digital world. These concepts will provide the necessary paradigm shift from anonymous solution this is almost impossible in the digital sphere to more holistic approach of the person. As you know, Article 3 of the EU Charter makes it possible to prevent two basic foundations of human existence from threats. On one hand, it gives the right to dispose of one's body at one's discretion. With other, it protects against practices that are unworthy. It helps outline the boundaries of human existence. The concept of digital integrity may be hard to understand without long theoretical explanation, but I think this is to understand through the function that it can perform. First, it provides the protection for a person's digital existence. The life of a modern person is not developing in only two different dimensions, which are interconnected with digital existence as well. It is impossible to legally protect one dimension and ignore the other. Second, it will legally consolidate a new relationship between a person and his personal data, recognizing personal data as an element of a person, as a building blocks for his identity. However, the personal data protection regime does not allow the existence of such relationship. Third, the European data protection law is based on the assumption that people should control their personal data, but only some provision of the GDPR can be based on this idea. In this context, the right to digital integrity is the effective mechanism for returning a person's control over his data. It is important for one reason more. As you know, the EU is talking about its digital sovereignty. One of the so-called levels of the concept of digital sovereignty of the European Union is the person's digital self-determination with the assumption of controlling data. And finally, it will help to determine the unworthy behavior in relation to the digital dimension of the person and justify possible prohibitions of the use of certain specific invasive technology. It is important to recognize the right to digital integrity from the point of view of protecting human dignity, using the respective aspect of human dignity. It can help to prohibit in unworthy practice, such as mass surveillance, profiling in the digital sphere. Note, the restrictive aspect of the human dignity is aimed at protecting those who do not have full self-determination. Analysis of current regime for the protection of personal data shows that data subject almost never has such self-determination in the digital world and is almost vulnerable. It is enough to note that the emergence of modern information technology make it possible to create a person's identity from his digital components, regardless of his action or consent. Recognizing the right to digital integrity and considering it as a basic for the regulation of personal data protection will protect person even if the latter does not know about the existence of collecting data. A person should not only be able to control information about himself, but also be sure that if such control is completely impossible, no one will transfer or use his information to his detriment, even if he agrees. Recognition of digital integrity is the basis for digital right, and as a new manifestation of the restrictive concept of human dignity will help to increase the level of effective protection of the person in the digital sphere and weaken the existing trend of recognition of ownership of personal data and data commodification. Thank you for your attention.
Thank you very much. I mean, there's a lot of concepts. There's which are the reverse of. We will talk a bit later. The reverse of the shift. Like someone should not. Right now, it is. I mean, Max Schremm case showed us that he had to know where everything was. He had to fight for a long time to understand how the system was working in order to protect himself. It opened up, of course, some changes in the regulations, but right now it's still considered, and even in the speech of people, that people tell you, well, if you don't want to be a victim on the data, then you shouldn't share the data with, you shouldn't use Facebook, you shouldn't use this and that. But actually that doesn't work like this, is that the data is there anywhere, is collected anywhere, and so you should have a legal principle that protects you even if you don't know where your data is. So the other term that really strikes me, because that's going to be the link with Alexandra again, is you mentioned the digital existence of the person, and so in the text of the new text, hopefully that is going to be voted, there is one I think exceptional concept which appears for the first time in the Constitution, which is the concept of digital life. And maybe, so that appears for the first time, I think, in any constitution. Even the previous work in Valais didn't have it, and other cantons didn't have this term. And so maybe can you explain why did you put it there? And also like start to go through the other rights, because these sub-rights are like really fundamental to give a kind of like a better understanding of what it means, the digital integrity in the Constitution.
Sure. Gladly. Thank you, Alexis. So in the political discussion that took place within Parliament and then with the government, the several decisions were made as opposed to the original proposal. One was to create a new article on digital integrity. So that's a new article in and of itself. That's a strong political message per se. Everyone has the right to the protection of their digital integrity. Alinea 1, so first, how do you say paragraph? First paragraph. Second paragraph, digital integrity includes, amongst others, 4 sub-rights, as you described them just now, to illustrate for the courts, basically, what that covers. These are the right to be protected against the abusive treatment of data related to one's digital life. So this is where this idea of digital life shows up. So it's not limited to only the data that the government already holds on you. It's any other data related to your digital life. The second one is the right to digital security, security in the cyberspace, let's say. This you referred to as well before when discussing what the police can and cannot do. The third is the right to an offline life. That specifically and most directly means that the government cannot force you to interact with it only through a digital channel. So that is something that already exists in the law in Geneva. Now it's going into a fundamental right in the Constitution. And the fourth is the right to be forgotten, le droit à l'oubli. So that sort of your data can be erased, given up on, and that you can request that. We have a third paragraph. I should actually have planned to just project it so you could read along even in French. The fourth paragraph, but you find it online. I can give you the references if that is useful later on. The third paragraph is very much in line with data protection and privacy intentions related to the handling of personal data by the state that can only take place abroad, so outside of Switzerland, if an adequate level of protection is granted there. So that's a pretty standard sentence. And the fourth paragraph gives a whole range of more political intentions. So sort of broadens this right to digital integrity on an individual level to more systemic things. The state encourages digital inclusion. The state sensitizes or communicates to the population what the challenges of the digital era are. And I feel like that echoes what you were saying earlier, Harry, about sort of we're building the infrastructure. The assumption we have to make right now is that this infrastructure is as it is, and that unfortunately nowadays still it depends on the individual and the individual's choice to select such and such a technology, use such and such a service, and be particularly mindful of one's data. So here, what the state of Geneva would then have to do is the responsibility to inform the population about this. So it sort of reduces a little bit the individual responsibility there. And the third political idea is that Geneva works towards the digital sovereignty of Switzerland and contributes to realizing it. So here the digital sovereignty of Switzerland is understood as the strategic autonomy of a country in regard to the state, to the economy, and to democracy.
Thank you. Thank you very much. And before we're going to finish with Lusine, who is in her paper, she makes, based on this description of the right to digital integrity, she makes a critic of GDPR. So the first two comments I'm going to add. First is one of the first questions we had during the commission work was, we should make a law, right? Because we're changing something in the constitution, then we need to make a law about the right to digital integrity. And my first reaction was to say no, and actually, so it kind of hopeful. Eventually, it convinced everyone, because if you look at how other fundamental rights are prepared, they are put in the constitution first, and then usually there are sets of laws which already kind of like work together. So here in this case, the natural field, and I think this is the step that the law specifically needs to change, is that the data protection law of the canton is, or of the government, or the GDPR that we'll talk a bit later, is actually the application law of this right. But instead of anchoring this data protection law in the article about privacy, because this is right now in the header of the data protection law, it refers to privacy. It's actually to anchor it on the right to digital integrity, which would be a bit higher in the hierarchy and a bit larger, like we said. And the other points I want to mention is that, so you mentioned the rights, the sub-rights, which have been defined in Geneva. And but the other cantons have like slightly. I mean, they're all coming up a bit the same, but there's some like small variation which I really appreciate to have them. So about the abusive treatment of data, the Valais went a bit further away. They actually say that you're protected against the non-consensual use of your data. So you shouldn't be able to demonstrate an abuse on the data. Is by definition, if there is non-consensual usage of the data, that is already something that you should be protected from the government perspective. And then the one sub-right, which is I think the most controversial one, but it's actually coming back to the tools of privacy, is and so it was initiated in Valais, but they kind of refused it in commission work. It was just like one vote, they said no. And then we pushed it again. The Parliament of Neuchâtel is actually pushing the debate on the right not to be surveilled, monitored, and analyzed. So basically, that's a right where it's breaking away. So the right to digital integrity is about recognizing the autonomy of the person digitally, but then there is this like push of saying, well, actually, if you want to go to the extent of that, to the full extent of that thinking, is then the institutions around the individual should not build or not use tools that have mass surveillance built in, data collection built in, and there should be like almost, you can imagine a country with zero knowledge citizens. You don't know the data of the citizens. It's kind of the extreme view. So let's go, Lusine. Maybe you had some thoughts about GDPR, and then we can close this and with an appeal that you already said, like the integrating in the European framework that would be anchoring this in the Fundamental Charter of Human Rights, Article 3, I think.
Yes.
Please.
Actually, GDPR has two clear goals. One of ensure the data protection. The another one is a free flow of data. Data. And in this regard, it is quite interesting. It's a controversive two goals, although the case law of the Court of Justice say that the telos of the protection of digital rights is this prevail, but the whole legal documents has provisions which are market oriented. And it is quite interesting because we say that data protection is fundamental rights and it's implemented by the GDPR. But GDPR has market-oriented approach. It is right. It is the way for commodification of data. And I think that digital integrity, if it will be introduced as a fundamental right, give a more comprehensive, out-of-market approach for the protection. It will be right, fundamental rights without market basis and without any problem with the interpretation of personal data as economic assets.
Yes, thank you very much. Yeah, so this is I think like one of the takeaway that it is a way out or having another approach of the data market, and we hope that. That will create a third zone. It has also some geopolitical impact because it would create a third zone between the data as a commodity, data as a public good, and data as element of the person. And but if you think about data as element of the person, then you get out of these market-driven tools. And so the small story, the fun story about this, because we are in a market, right now we have constructed the data market, and GDPR or even the data protection law in Switzerland is also a market-based approach. It's the same approach. Basically, the most critic people we have in Switzerland, Alexander was saying that there's a consensus, there's a political consensus on the topic. There's also in the population, it's very consensual, but there's some data protection specialists are critical to it because they see it as a way to lose their kind of like understanding of the market. And so they're being critical, that's an interesting small side effect of this. I think we have just a couple of more minutes for questions. If there are some, we're welcome to have some. Yes, there's a microphone just here. Yeah.
I just have one small question coming from perspective of digital divide. Does the fundamental right to digital integrity, should it also include the right to access internet? Because like in more developing countries, not everyone has internet, but digital integrity is still an issue.
Yeah. So this is a historical thing. I think the right to be connected was always it was the first right that was brought up. So in the 90s, it was already talked about it, but we were already seeing that there was a risk. Is that actually human beings are social by nature, and today everything happens online, right? So there is, and because it's so efficient, actually people are pushed online by mechanism, which it makes it cheaper and more efficient. So basically, the right to be online is eventually is going to be guaranteed anyway. We can argue that. But what is the important is that at the beginning in the 90s, only the rich people and the smart people could be connected, and the poor people were not connected. And now it's the opposite around. We see that poor people are forced to be connected, and they are forced to use. We had the case in France. People who want to register for unemployment have to use a digital device. For people who sometimes don't speak the right language, are not from the level, and they were losing on their social benefits, on their unemployment benefits, because they could not use the device, right? So they were forced to be connected, and they were not giving the rights not to be connected.
Yes, like in India also for COVID, the government mandated that everyone downloads an app. But
that's
for
an example, yeah.
like to grant a fundamental right to digital integrity, there has to be a precursor to digital access also, right?
Yeah, I mean, it goes with it, but I think also here you have to consider that fundamental rights, every fundamental rights that is being picked up has some very cultural and aspect between like the context of the country.
Yes.
So in Switzerland, the digital divide is tiny. It exists, but it's tiny. But maybe you have some thoughts about this because
if I may,
you
sure.
have.
I think when we talk about the digital divide, we sort of look at it from like in 3 dimensions. One is, do I effectively have a smartphone or a computer or a device that has an access to the internet? Does the place I live or I work actually have the access to the network? So that's the first dimension, and that largely in Switzerland, we have a very high rate of people with access to the internet in that sense. The 2 other ones are more complicated. The second is, do I have the competencies? Am I able to use this device and this access for what I want to use it? So it's one thing, the key sort of, a young person would be great at total caricature minute here, yeah? Would be great at making a TikTok dance, not necessarily that great at finding a local business that could train them and write up the proper letter and application, yeah? That's a total, and likewise, elderly people might have challenges in other dimensions. And the third one is, does the person have a place or a person they can go to that will help them to acquire the competencies that they need? And certainly on these 2 dimensions, at least in Geneva, we still have some work to do. And so we have actually written it into the proposal for the constitution, as in the state acts to favor digital inclusion.
Thank you so much. It was really nice. We'll wait for June 18th, I guess.
Thank you. Any other question? No? Yeah? Yeah? Can you speak in the microphone because it's recorded there? Thank you.
I think there's a few questions. It's hard to see without seeing the text here. Firstly, there are lots of situations. A lot of the words that you are using, like analysis or surveillance, firstly, they come with a metaphor of data collection and data access. And we also know that the data collection, data access is not really the core, I think, of digital surveillance. It's a bit of a temporary metaphor. And we find that analysis of groups or optimization of people or optimization of our digital environment is not always about collecting information about people. We also see a lot of things that we could term surveillance, but actually are forms of control that don't require data access at all. So look at these approaches of privacy-preserving advertising, targeting, machine learning recommendation that all happen on the device. So firstly, I'd wonder, why this focus on collection and access that seems to be coming out about integrity there. And secondly, this focus on the individual. A lot of this actually happens at a group level, at population level, and so on. And I'm wondering how you balance that. And lastly, a lot of the areas of data analysis of people, where they're required, whether it's a public health or other areas, the reason the right to private life is a qualified right is because there are loads of things that interfere with the right to privacy but are justified interferences. And I see the initial statement around Big Brother Watch went too far, said that actually there was a way to justify this interference, and that's it's a controversial decision for some people. I agree, but it seems like you don't have that escape valve here, and it seems very easy to then imagine lots of situations which involve the conflicting right of other people. For example, in a criminal situation where someone is alleging harassment at work and somebody's device might need to be looked at, or in situations of civil wrongs, or other times where public health, for example, might override other areas of digital integrity, where there are justifications to survey and to analyze and to examine people. And maybe you could say more about how in this area that valve and that balancing works in a way that's different from the right to private life, which, let's not forget, also includes bodily integrity and has integrity aspects in the right to private life, because the right to data protection is separate from the right to private life in European law anyway.
Yeah, so on the first point, actually the word data is not written in any of those texts. So, we talk about collection. I talked about collection of data because that's the one of the easy entry points when we think about a person and its data. And those concepts and how they're written up, it makes a total abstraction. It's from the data. It goes from the principle that person doesn't need to know about this data. It has a digital existence, and that the relationship between its institutions and the citizens should be in a way that the autonomy of the person, whatever the mechanism are used, is always conserved. Whatever data is treated or how it's used, right? So there is an abstraction level that happens, and we don't talk in the law about the data itself. Maybe you want to chip in?
So we do mention the right to be protected against the abusive use of the data related to digital life. To the third or fourth point, I agree with you. Like, any fundamental right does have limits and can be limited. We're not saying it's an absolute right. I think that's an important point you're making there.
So how is it different then? How would it result in Big Brother Watch being decided differently? Which is the point that was made earlier on. Why would this right lead a court to say that national security would not allow an interference in bulk collection and similar, or are you just looking for different judges on the right to private life?
No, but it's you have the idea is to switch the approach. Let's take example of bodily integrity, right? Because that's already existing, right? The individual has a right to physical integrity. That means what? That means that if I'm going to vote and I'm going into the public office, and I'm going to use a very stupid example, so don't blame me on the stupid example. If you enter the voting place, if there is a guard there who beats you up for no reason, he just beats you up when you enter, you're not going to vote the same way as if no one beats you up, right? So the influence on so that's why that's a very basic reason to say why in order to have a functioning democracy and with people who are free in their mind and capable of taking their own decisions, they need the institutions should not harm their physical body, should respect their physical integrity in normal cases to maximize their autonomy. Now, we still put people in jail, we still arrest criminals, police still has can use can restrict physical can restrict people. Doctors can intervene without the consent of the patients in life-threatening situation, right? All these things happens, but they have been developed by they have been developed by jurisprudence. They have been developed on the way of based on the current situation, but also based on morals, right? Because also the morals evolve, and slapping a kid a few years ago was still okay. Today, it's not okay anymore based on the morals that have shifted, right? So that's the work that needs to be done and will be done now through trials and through laws and concept and practice also. The government institution now who are going to implement these things are going to find out things. And they will have people who are well educated or not enough educated. There will be discussions, and all these things will take time. It's a long process. It's a generational process. The same way as we have built the whole concept around how physical integrity should be respected up to which point. You can go to the hairdresser and have a haircut. It's actually cutting an organ of your body, but it's still okay. We consider it's fine, right? But you cannot sell your liver like this on the market. These have to be thought out by the people implementing this. So there's a principle base.
Yeah, I mean, it's fine. I think that I like the call to say, look, we should take your digital rights and so on more seriously. I just wonder, it's very, very under-theorized what you're presenting, it seems. It seems that you can get to those positions from lots of different directions, from lots of different elaborations of different kinds of rights, including the right to private life, which can go in that direction.
That for me is actually, that was one of my criticism, that the right to privacy, if you just look at it in a pure hierarchical view in terms of norms, right? You have life, right to dignity, and actually the charter of the European Charter of Fundamental Rights is built like this. First article is right to life, second article right to dignity, third is right to integrity. Privacy comes later on, right? And it doesn't mean that you can do a lot already with privacy, but it does create a mental framework, and so this kind of changes, and this is where also we had the critics about, okay, but what is the definition of digital integrity? Give me the right definition, right? But actually, if you look for the definition of physical integrity, or even some concepts like what is the body in a purely legal way, you don't have this definition doesn't exist. So here, what is a bit sometimes what is a bit new also is that we're entering into a type of domain which is hyper technical, where we define everything. We put definitions of all the words all the time. When we make a law or we make a text, there's a first set is a big series of definition. And here we're taking a term and we say specifically we don't define it, and we let the concept evolve in there. And this is how the initial human rights were actually set up too. If you want to say something else? No? Okay. Well, No, thank you very much, and yeah, please read the text of the Constitution of Geneva. That's interesting, and the research. I'm going to say it again. It's on Sciendo and ResearchGate. I mean, it's available everywhere. It's called Digital Integrity: A Foundation for Digital Rights and the New Manifestation of Human Dignity by Lusine. Yeah. Thank you very much.